From us. I just tried to do it. And
Okay.
I have to request your.
Yep. No.
Oh, you're doing it.
It's rolling. Okay.
Nice.
Now where? There's that.
Yay.
All right. Hopefully this isn't too bright in everybody's eyes. Come on now.
I can barely see it myself.
I can attest it was working before. He did just.
Oh yeah, it'll turn on in just a second. Come on, girl.
Needs a cup of coffee.
There we go.
There we go.
There we go. Okay, I'm gonna kill the front light. Oh, what did I do?
You just straighten up. We
whacked
moved
it.
the table.
The table got moved too, so.
Oh, yeah. All right. That's yours. That's all right.
What?
You hit it.
Oh,
Yeah. Okay, so deep breath. All right. So thank you guys for showing up. I sure appreciate it. I know this is going to be timely for some of you and a day late for at least one of you. And I'm sorry. What Zara and I wanted to talk today about is giving testimony in court. You guys have all been to court, or almost all of you have been to court. You will soon. But
That's scary.
okay, but the typical court that we go to is not what I'm going to be talking about today. When you go to court and the judge is asking, people to, like a review hearing, the judge has read the reports, he'll listen to any arguments of counsel, and then he'll make a ruling, and you're out there in 5 minutes. That's not what we're talking about today. By testimony, what I mean is you formally get up on the witness stand, you raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, and then people start grilling you. Okay? Testimony is what happens at what we call a fact-finding. Okay? Fact-finding, the active process of determining the, oh, there's a window in my way, determining the facts of a case and applying those facts to the correct legal I wonder if I can make that go away. I bet I can. I bet I can.
There you go. Got it.
Boom. There. Ha ha
I'm
ha.
watching for messages.
Oh, thank you. Okay. So, active process of determining the facts in a case and applying those facts to the correct legal standard in order to reach a decision. This is a trial. The reason they call it a fact-finding is because there's no jury. When you use the word trial to a lawyer, they're going to think you're talking about a jury trial, unless they explicitly say bench trial. And you will hear people call it a bench trial once in a while. But these are called fact findings. So the adjudicatory hearing is a perfect example of a trial. Okay, so like I was saying, trial is not the same thing as a hearing. It's not a review hearing. It's not that pre-trial conference. It's different. There's a difference in standards of proof that has to be met at a trial. There's a difference in the rules of evidence, and we're going to talk a little bit about rules of evidence. This isn't a law school class, but I'm going to teach you a few things that you do need to know. And then, of course, today's topic is the judge takes testimony. All right. It's important to know, and I know you guys have seen trials on television, and most of the time they don't get it right, but my wife hates watching legal shows with me. She hates it. She's like, no, honey, if you're going to watch Law & Order, I'm leaving the room. I had to give up Law & Order, right?
I think we have an attorney in this person's question.
Right? Okay. So fact-finding is an adversarial process. What I mean by this is the judge doesn't interview witnesses. He doesn't go out and do home visits. He doesn't talk to the children. That's what he relies on you for. So when we're not joking when we say that you guys are the eyes and ears of the court. That's what we mean. But in the course of a trial, the judge relies on attorneys for each side to present their cases, and he wants them done thoroughly and efficiently, because ain't nobody got that much time to waste. So that means the attorneys are responsible for presenting only the information that is true, relevant, and admissible. Okay? Relevant means it has some bearing upon or it's connected with the matter that the judge is supposed to be looking at. Admissible means it conforms to the rules of evidence. Right? But they also have to present the evidence that will be more persuasive to the court. So there's a tension there. True, relevant, and admissible sometimes isn't the most persuasive. So that's why we have rules on what can come in and what can't come in. And that's just designed to guarantee that the process is fair. Okay? We call it a fact finding. The judge is the finder of fact. Like I said, there's no juries. So it's important to understand that trial isn't about convincing the judge what the law is. Trial is about convincing the judge what the facts are. And then the attorneys argue how the judge should apply the law to those facts. Okay? So if you imagine that from the time the trial begins, judge has got a notepad and he's writing down each piece of information that needs to go into his decision as he hears it during the trial. What kind of things would he be writing down? Okay, personal observations of witnesses. Somebody saw something, they put them on the witness stand, they tell about what they saw or heard. Okay, things they've personally observed. Expert opinions. Now, without getting too technical, ordinary witnesses most of the time aren't allowed to give their opinions. They're not allowed to speculate. They're allowed to testify to the facts and only those facts about which they have direct knowledge. Expert witnesses, on the other hand, get a little latitude. They get to give professional opinions by virtue of their education or training or experience. A psychologist, for example, who examines one of the people involved in your case would be able not only to testify to what he observed during the exam, but his professional conclusions, which are an opinion. Okay, but unless you're an expert, you're not supposed to testify to your opinions. All right. And then the judge can hear arguments of attorneys about what the legal conclusion should be in light of the facts and opinions that the judge has heard. So where do you guys fit in? Guesses? Sometimes. Sometimes. But what are your recommendations? You're not.
What?
You're not an expert witness, at least not solely by virtue of being a guardian ad litem. Now, some of you may have, and some of our volunteers do have extensive professional qualifications who could qualify as expert witnesses on their own. But when you're a GAL, you're not an expert witness just because you're a GAL. What you are is a court-ordered investigator, and you have specific powers and responsibilities to investigate the case, the child, make recommendations to the court. You may be, in some cases, a fact witness. You're not just going to testify about things you learn in your investigation from other people. You're going to testify about what you see too. So you can testify to those things. But you also have a responsibility to advocate, and part of advocating means having an opinion about what to advocate for. But you're not an expert. You're in this weird kind of in-between fact witness and expert witness, and you're kind of some of both. But because you have these duties that are imposed on you by statute, and the judge signed an order appointing you to do those things, you have to do them. So it's fair that the judge can hear not only what you saw, but what you think that means, and what you believe the judge should order. Okay? So even though you're not an expert, you do get to give your opinion. Yes?
Sorry, will they
Yeah.
specifically ask that? I mean, you have to just answer what they ask, right? So you don't just go straight from I witnessed this and then my opinion is this, right?
We'll get to that a little bit, but I mean, as far as like strategy, well, we will touch on a lot of this. So that's a good question. Hang on to it. We'll keep that in the parking lot for just now. Okay, so what can the judge hear? He can hear personal observations from fact witnesses, expert opinions, your recommendations, and that includes some of the evidence that you learned during the course of your investigation, even if you didn't personally witness it, and then the arguments of counsel. But now a judge isn't supposed to hear secondhand information. So like he's got a witness on the stand and the witness is testifying to what they learned from somebody else. Judge isn't supposed to hear that. And remember, we said rules of evidence are designed to guarantee the fairness of the process. So what's wrong with secondhand information? Well,
It can't be questioned.
you're skipping ahead.
It
Yes.
can't be questioned.
Yes. Right. Oh, hey. Yes. It's prone to corruption. Anybody ever play that game telephone? Where by the time it gets around the room, what you originally said is there's no relation to what you heard back. And you can't cross-examine it. You know, you testified to what you heard from somebody. Well, what did they mean by that? I don't know. That's just what they told me. So it's not fair in many cases, to give secondhand information because it can't be cross-examined and it's prone to corruption. So yeah, we are talking about hearsay. Hearsay is a statement made by somebody other than the person who's testifying on the stand, offered as proof of what the statement says. Mom was falling down drunk. How do you know? I heard it from the bartender. That's not fair. They can't cross-examine the bartender, get deep. Well, how do you know she's falling down drunk? See? All right. Trouble is, a lot of your report is made up of hearsay, and many of your recommendations are going to be based on hearsay too. So, here's the most important thing you need to know about hearsay. Let the attorneys worry about hearsay. Okay? Put a bookmark in there, because we're going to talk about some strategies, and then we're going to talk about some other strategies later that don't have anything to do with the rules of evidence, but it's important to keep this in mind. Let the attorneys worry about hearsay for a bunch of reasons. Statement is only inadmissible if the opposing counsel objects. Okay? And there might be really good strategic reasons why mom's attorney doesn't object when you offer hearsay. We'll talk a little bit more about that in a bit.
So does the judge then, if hearsay is admitted, the counsel doesn't object, then does the judge write it down?
If it's relevant to the case, yes. Oh yeah. Okay. Well.
Agenda.
I'm just still a little raw.
Yeah. It's getting better. Far fewer judges now. Okay. So I said let the attorneys worry about hearsay, but there is one exception I do want you to walk away with today. Statements made by a party opponent are not objectionable just because they're hearsay. What do I mean by a party opponent? Another party to the case who's not you. Mom, dad, caseworker. You can offer statements made to you by mom or dad or the caseworker all the live long day. They're not hearsay. Based on what we said so far, do you know why?
No, because
They're a party to the case. They're right there in the courtroom. They can be cross-examined.
Or their attorneys are.
Right. Right.
Yeah, that's if they get there.
Yeah. Right. And the reason I want you to know
Sorry.
the reason I want you to know that is because it affects how you work your case. It affects how you handle your investigation. Sometimes a parent's own statement can often be the best evidence against them. I'm just overwhelmed. I just can't handle it. Okay. Make sure You document your conversations with parents, detailed, dates and times, and as close to exactly what they said as you can. Okay. That doesn't just apply to parents. Caseworkers. Caseworker says something to you offhand that contradicts what comes out in the case plan report 2 weeks later. Okay. That statement may be useful if you're advocating for something different than what the caseworker is recommending. Okay. So, all right, now I'm going to get back to Karen's question. Let's talk about some strategies for dealing with hearsay. And the first one is just state the facts, no matter where you heard them. Okay, leave out the source. Omit it. Omit the attributive modifiers. The chemical dependency counselor told me. Okay, because here's the reality. Attorneys during a trial have 18 different things going on, up to and including trying to figure out what they want to have for lunch, right? There's 18 different things going on in their head. They're listening for keywords. She said, she told me, objection. Okay, there's a little part in the back of their brain that's listening for that so they can jump up and objection, hearsay. If you never say that, well, it sounds like cheating, but if you never say that, they don't automatically jump up and object. They may think about it and decide that they want to object, but it won't happen automatically. And if they do object and ask, okay, well, what's your basis of knowledge? And we'll get into some of that in a bit. But if they ask you, you can say, that was reported to me by the chemical dependency counselor. And maybe it comes in and maybe they don't. Maybe it doesn't.
That seems so counterintuitive because I feel like, we would be saying, well, the teacher told me,
Right.
his fifth grade teacher told me that she was concerned about such and such or whatever. It feels like that would be almost accepted that,
Right.
that we wouldn't just say.
But it doesn't set
Teachers are concerned about.
It doesn't
yeah.
set the bells off with the. It doesn't set the
Yeah,
bells
that's-
off with the lawyer if you just say I was
Right.
told.
Because we're gonna put that in our report.
Oh yeah, it's totally going to be in the
Our reports are
report.
gonna have everything, and if they do ask, we know that, we have that, information, but we're just talking about specifying, trying to get the information. So, figure out.
Yeah, so how would you say, medical dependency counsel told me that? Do you just say?
You just say he's missing most of his appointments.
He's missing most of his appointments.
Yep.
Don't say where okay.
He's
Right.
only made one appointment.
Yeah.
He's only been to
He's
half
missed.
appointment.
He's missed 60% of his
He's had
appointments.
six dirty UAs in the last 8 weeks.
Okay. That's
Yeah.
that.
It is.
Well, you have to.
It is,
before
but
you
it's
were at
and in the case of UAs, I guess you would have documentation. So, but he's not coming to group. You probably don't have the attendance sheets from group. So he's not coming to group.
But what if we have like the notes from the counselor that say that? Does that count? Because sometimes
No,
we
that's
get
still hearsay.
reports. That's still hearsay.
That's still hearsay.
Then why isn't a UA result hearsay? Because that's from somebody else that's not there that can't be cross-examined.
If you have a documented though report from the UA.
Yeah, but if you have a documented report from the counselor that says they're missing half their appointments.
The difference is a UA is a laboratory result, and there's rules governing those.
follow it.
That's why they're all certified at the bottom, and their
Okay.
standards
Yeah.
are printed. And
But saying they're missing their appointments, and we haven't seen the appointment, but we're taking the counselor's word for it.
and they're not there to be cross-examined, right?
Yeah.
And yeah, so, but we can still say that, and unless it's questioned, then it goes.
And if the attorney jumps up anyway because he's anticipating you're going to say that and he's waiting for you, he may object anyway. Objection, lack of foundation, and we'll talk about this in a bit. But you don't have any personal basis of knowledge for that. Maybe the judge sustains it, but he heard it.
And I say, but the key to that is the information is out there. Once they hear it, they can't unhear it.
Can't
Even if
unring the
they
bell.
say, strike that from the record, pretend you didn't hear that.
Yeah.
To the jury.
Well, and we'll talk a little bit about the fact that there's not a jury.
Yeah.
Because the fact that there's not a jury actually makes a big difference in how some of these things work. But we'll talk about that. Okay. So just state the facts no matter where you heard them. Omit the attributive modifiers. Like I said, unless it's mom told me or dad told me, because dependency lawyers know that if the statement starts with mom told me or dad told me, it's a waste of time to object. Because statements by a party opponent are infinite. Yep. And then don't telegraph the hearsay. I had a witness one time, looked at the judge and said, I don't know if I'm allowed to say this because it's hearsay. What did opposing counsel do? Jumped to his feet, said, objection. So don't telegraph the hearsay because she never even got a chance to say what it was. Right?
Basically saying, oh, I'm giving you hearsay.
Right. Well, yeah, I don't know if I'm allowed to say this because it's hearsay. Don't say that.
It is.
All right. Hearsay isn't the only basis upon which an attorney might object during your testimony. There's two big kinds of objections. Sometimes the question you were asked might be objectionable. Here's one you might actually run into. What do you think will happen if the children are returned home? It's asking you to speculate. It's asking you to guess. You don't know.
But aren't you making an educated guess based on what you've seen and observed
Yes.
for the last year?
Yeah, but that's an objectionable question.
That doesn't mean they will object to it. It just
Right.
means
It could be.
Right.
it could be.
A statement's only inadmissible if the other attorney objects. And there may be great reasons why they don't want to object. They might object and the judge will say, rephrase the question, and the attorney will find a more artful way of asking you the same thing. Okay. The judge will usually give the examining attorney a chance to rephrase the question. But sometimes it's not the question that's bad, it's the answer that you give. So, handling objections. If there's an objection to the question, like if before you start answering, the attorney's objecting, calls for speculation or whatever. If there's an objection to the question before you start answering, don't start. Wait for the judge to rule on the objection. And you've seen this on TV. They might overrule the objection and say, go ahead and answer. They might sustain the objection but allow the attorney to rephrase it. They might sustain the objection and order the attorney to move on to something else. Or the attorney may just withdraw the question. Now, if there's an objection, what happened? Why aren't we making it clicky? Oh. Whoa. Just a sec. I don't know what happened. Oh, gosh. Okay. I expect it has. Oh. I'm gonna bring it back. I swear to God. I'm gonna bring it back.
It's my ringtone too. I'm like,
It's my daughter.
All right. Oh, for crying out loud.
Jumping.
Well, yeah, I just skipped over part of my slide, and I don't know why. Okay. These are just a few examples. There's 12.5 different reasons why there might be something wrong, but the most common ones you're going to find is relevance. And you've heard people say that on TV. Objection relevance means that the answer you gave really doesn't have anything to do with any of the issues at hand in the case. Okay, that's not your fault. You might have been asked a bad question. We're going to go over how to avoid that one. And relevance can be really subjective. Judges, especially in child protective cases, are willing to hear a lot of information that doesn't seem directly connected because they need to know about the circumstances of the child in a broad sense. Another one you're likely to hear is non-responsive. Objection, non-responsive. Frequently, you'll get an attorney ask you a question, you'll give them an answer, and they'll object. The attorney who asked you the question will object to your answer. Because What he's saying is you answered a question other than the question he asked you. So, so you need to know what that one means.
That's what non-responsive.
That's what non-responsive.
Can you say that again? I'm sorry.
Non-responsive means the answer that you gave isn't actually an answer to the exact question that was asked.
So who says that then? Like,
The lawyer that you just got questioned by.
we'll say that's
Sometimes,
non-responsive.
sometimes.
Any
Yeah.
attorney.
Right.
Yeah. Yeah. But like, I'm having trouble coming up with a good example of that one. But I mean, if the attorney asked you, for example, and this is something that could happen. The attorney asks you, did you get counseling records from Riverside Recovery? And you say, we got all the records that were provided to us
Ask
in
that.
time for today's hearing.
You didn't answer whether you got
Right.
records or not.
Right. He asked you a yes or no question. And you gave him a big, broad answer that was way bigger than the question he asked. You were answering the question. You know, and maybe you would have continued, if he hadn't stopped you with an objection, maybe you would have finished and said, so yes, I'm fairly confident we got those. You might have even finished and wound up answering his question, but you weren't answering it the way you wanted you to. Okay. Lax foundation, I mentioned that one earlier. What that means is the attorney who asked you the question probably jumped too far ahead. Without getting too much into detail, getting evidence in is like laying cobblestones in a street, right? You know, if you're laying this foundation and all of a sudden you're 6 feet ahead and you haven't put any of the stones in between there, you're going to end up trudging through a lot of mud before you get to where the evidence is. There has to be a basis for everything that's introduced. If you're trying to introduce a document, okay, what's it purport to be? Somebody has to authenticate it. You know, there has to be a basis for all the information that comes in. Personal knowledge we talked about, but it could be other things. Where did this come from? You know, how do you know this? That's what foundation means, and that's where you state a fact that you really got from hearsay. You state that fact, and that's where the attorney may stand up and object on the lack of foundation. Well, I haven't heard the witness say how they could possibly know this. Did they personally observe this? Were they sitting in group every night? Okay.
You say no to the judge.
They could be.
See if the judge is gonna put forward.
Right. Okay, and then of course there's hearsay. All right. Oh,
That works.
oh, that's weird. I wonder if I dorked my order. Okay. All right. Some attorneys are more aggressive than others, and they're going to engage with every tiny little detail. I think we have one here in Nez Perce County, from what I've heard. Okay. They were on the mock trial team since high school, man. They're ready to go.
Are there
Okay.
too many shows?
They're new.
They're new. Many attorneys keep their objections to a minimum during a fact finding because judges tend to have a lot of faith in their own ability to determine what evidence is admissible. So if you got an attorney who's objecting to every other question, pretty soon the judge is going to say, counsel, I've been doing this a while. I think I'm capable of determining what is and is not hearsay. Thank you. So nobody wants to piss off the judge. Some attorneys will object a lot just to throw you off the rhythm. And honestly, in my experience, it's not parents' counsel who are going to do this. If you're going to come up with that, if you're going to encounter that, it's because you're not quite in line with what the department wants. And it's going to come from the prosecutor.
Wow. From the prosecutor or the department?
The prosecutor is the department's
Is the
attorney.
department. And that's usually, I would assume, if you have a different opinion than what the state
Right.
wants for these kids.
Right. So some attorneys are going to object just to mess with you, especially if they don't like what they know you're going to say. Okay. Trial strategy and tactics go on behind the scenes all the time. And on any particular case, maybe your attorney will share some of that stuff with you, and maybe he won't. Most of the time, it's not something you need to be concerned about if you've done your prep work. And we're going to talk about what I mean by that. But like I said, besides not irritating the judge, there's lots of other reasons why parents' counsel especially might not object when you say something. A big one being, maybe they know you're right,
It's blatantly honest.
right?
that you're-
They know their client hasn't been going to group. So, because what happens if they object? You're going to get that evidence in somehow, and if it means we have to recess the trial and subpoena the counselor to come in and say, yeah, he's missed 6 of the last 8 group sessions. Oh, and by the way, in group, he talked about how he's thinking about trying heroin just for fun, right? There could be something way more damaging if they jump back a step and get rid of the hearsay and go to the person who actually made the statement. Way more bad stuff might come in, right? So they don't want that person on the stand. That's just one example. So it's a good idea to anticipate objections. If they don't object, don't let it bother you. Okay. Preparation can go a long way toward making sure that everything you need to say comes in. Practice your answers. You know what kind of stuff they're going to ask you about. And practicing.
Do the CASA attorneys, are they willing to help us put that together?
That's a good question.
They are, and oftentimes like for termination trials or something like that, where we know we're gonna be on the stand, they'll meet with us in advance
Okay, good.
and go over those things, yeah.
And the prosecuting attorney
Yeah,
with us
They will
to
too.
tell us questions that they're.
Oh, okay.
Oh,
All right.
really?
they will.
Even-
and
oh,
that's
Lincoln
nice.
County.
Even if
They
they're,
will if
Oh,
we're
wow.
in agreement.
if we're in,
Yeah.
if we're different, say if we have a different thought process and we're not agreeing with them, is that still that prosecutor? They're not going to come back and say, oh, well, we'll tell you what we're going to do, because
Yeah.
they're not going to be happy because we're already disagreeing with them.
Because they
Right.
And I was paying attention to how the person from the department, what questions were asked of her, and I'm like, oh, I need to have an answer to that. Okay, this is what- Oh, I need to have an answer to that. This is what I'm thinking, while they're talking to her first.
Yeah, that does. Although, I mean, I'm going to suggest that you have those answers before the
Before you
trial
get started,
starts.
yeah.
Well,
But
I mean, sometimes
you
you're
were
put on
walking
the
into
spot,
it,
it's
right.
like, oh, we might have you testify about this part today.
yes,
Then you know about, and they can't look at it, so.
that is a fantastic point. If you hear a question come up, if they examine the caseworker first, and you hear a question come up, and you think, oh, I better have an answer for that. It's a good idea to have one ready. Okay. Practice doesn't just help you say the words better. It helps you with all the other things that go into that. You're
Taking
Your
out
demeanor.
the he, she, she, whoever said.
right, taking out the
Yeah.
attributions.
Yeah.
Right.
Right.
Well, and remember, above all else, we want to be, and I'm going to talk about professionalism later, I promise. But above all else, you need to be calm. Right? Stay calm. Breathe. Right? So like the first time I was ever called up to the stand, my heart was pounding. And I've been in trials before, but never as a witness. First time I got called to the stand, my heart was pounding. Breathe. Take deep breaths.
Sharon just asked if you could cry.
You
Yes.
could.
After.
She meant during.
None of the shenanigans that happen in the courtroom are personal. We'll talk more about this too. Your testimony isn't personal either. What anybody says to you, it's business. What you say about the parents, it's business. It's not personal. You're the one with facts. Okay. Any questions so far? We've talked a little bit about just like evidentiary rules and stuff. Now we're going to get into getting ready for trial. Okay. First three things you need to know. Here's your roadmap. What are the questions the judge has to find answers to? What do I know that's relevant to giving him those answers or her those answers? And who's going to call me as a witness? All right. So, what are the questions the judge has to get the answers to? It'll come right from the statute. So you always want to start with the statute that applies to the type of fact finding you're getting ready for. After getting ready for this, I have cheat sheets for every kind of trial you might ever face. So if you're looking like you're going to testify and you want a cheat sheet, give me a shout. I got it. All right.
Are the bench cards still posted online?
Yes,
Yeah.
they are.
Those are helpful.
Those are really good.
Those are really good to know.
And I need the adjudicator.
Okay, I'll hook you up. All right, so pop quiz. Fact finding or not? Shelter care hearing. How do you think it is?
Yeah.
Yeah?
Yeah.
All right, it is. Pretrial conference.
Yeah.
Why?
I
There's
didn't
no
get
judge
it.
there. No, that's in Lake County, another county.
Oh, yes. Before the record showcase, if they settle it at the probably.
Right. So yeah, pretrial conference, there's no, I mean, it's just, are we going to trial? Are there any motions that have to be heard before we go to trial? It's housekeeping. Nobody takes testimony there. All right, motion hearings, are they fact findings? Nope. The adjudicatory hearing, yes. How about a case plan hearing? Nope. Okay, status hearings, that's easy. No. Review hearings,
Review.
you think that's a fact finding?
It's a review, it's just a review.
Yeah. Do judges take testimony at review hearings?
No.
No. Permanency hearing? No. Termination?
Yes.
Yes. Okay, so these are the three we got to be worried about. Just those three.
No,
Yes.
one more aggravated circumstance.
Would that be held at the adjudicatory hearing or afterward?
It would be held anytime. They want to file for that.
What is that called? Aggravated.
Aggravated circumstance.
So that's a different kind of adjudicatory hearing under 1619, right?
Oh, so it's
It's, yeah, and if they have a separate adjudicatory hearing on whether aggravated circumstances are present, it's still a fact finding.
but it would just fall.
All right, so shelter care hearing. Everything you need to know is right in that section. What's the question at a shelter care hearing? Has a petition been filed? Is there reasonable cause to believe the child comes within the jurisdiction? And if you don't know what that means, I'll explain it on the next slide. Child can't be placed in the temporary sole custody of the non-offending parent. It's contrary to the welfare of the child to remain in the home, and the child should remain in temporary care pending the adjudicatory hearing. That's what the judge has to find. Okay? So, within the jurisdiction of the court has the child been neglected, abused, abandoned, homeless, or are the parents unable to provide us a stable home environment? That's what within the jurisdiction of the court means if nobody's ever told you that. Or a sibling living or having visitation with a child who is one of those 5 things in section 1. Okay? Not going to spend too much time on the shelter care because how likely is it that you'll ever have to testify at a shelter care hearing? Could happen. Like I said, you could be a fact witness, and you could have, even in that first 48 hours, it's possible that you've seen something or heard something that only you saw or heard that needs to come in at shelter care. So it's theoretically possible. But most of the time, we don't know crap yet. We know the names of the parties, but we probably haven't talked to anybody yet. So it's theoretically possible you might have to testify at a shelter care hearing, not very likely. The adjudicatory hearing. Oh, I skipped over something. I'm so sorry. Okay. The big question is there reasonable cause to believe the child comes within the jurisdiction of the court? Reasonable cause is the evidentiary standard required. If you think about it like criminal law, it's probable cause. It's not proved, it's just an allegation. But is there at least some evidence that this charge maybe could be proved when we go to trial? That's it. Very low evidentiary standard. And that's another reason why you're very unlikely to testify. Most of the time, if anybody testifies at a shelter care hearing, it's one person. Cop or caseworker. Maybe. Yeah, maybe. Yeah, because they might have independent facts, sure, that the judge needs to hear. Or maybe a cop knows about B and E, but he doesn't know about A and C and D, so they have to call the caseworker up to talk about those. Sure. Okay, so reasonable cause, really, really low standard. Is there some evidence to make me think there's a case here? All right. Current slide. Cool. Okay, adjudicatory hearing. If a preponderance of the evidence at the adjudicatory hearing shows the child comes within the court's jurisdiction, then the court shall so decree. I wish you guys had a better term over here than within the court's jurisdiction. Over there, they call it dependent. Over there, meaning in Washington. I'm sorry. It's so much easier to say dependent than a child within the jurisdiction of the court under 1603. So, all right. Preponderance of the evidence is a higher standard. 50% plus anything. 50.001%. If the judge believes the allegations just a little more than he believes that maybe the allegations are wrong. Okay? And that's the standard of evidence in most civil cases anyway. You've heard people talk about beyond a reasonable doubt. That's the one we use in criminal law. It means, yeah, aliens might have come down and did this thing, but other than that, I'm pretty sure your dude did it. Okay, that's beyond a reasonable doubt. Okay, preponderance of the evidence is way lower. He's just got to believe you a little more than he believes mom. Okay. So the big question, you're going to hear me talk about the big question a few times as we go through this, is the child within the court's jurisdiction? Abused, abandoned, neglected, homeless, parent failing to provide us a safe home environment, safe and stable home environment, or another child living with or having custodial visitation in the same household where another child is within the court's jurisdiction. Okay. So there's some other stuff though. If the child's found to be within the court's jurisdiction, the court will have to make some other findings at the adjudicatory hearing. Should the child remain in out-of-home placement, or can the child safely go back home, but keep the case open and keep the department on board doing supervision? That's a question about which you'll certainly have a recommendation and some evidence, okay, to present to the court to back up your recommendation. Reasonable efforts to prevent removal, and has the department tried to prevent removal, or is there a good reason why the department shouldn't be forced to try to prevent removal? Okay. You may have information about that, but mostly that'll come out of the caseworker's testimony, but you may know something. Indian child, you may have information about that, but probably not, because it's the department's responsibility to try and determine that and notify any tribes who might be implicated. But if you've made independent efforts of your own, I don't know if you ever would, but certainly you could testify about those. Educational stability, you may have a lot of information to present about that. And that's at just about every hearing on every case until the judge gets a concrete answer that's going to stay. He's going to be asking about Indian child, educational stability, sibling placement, and psychotropic meds. Educational stability means, is the child in the same school they were in when they were removed, or is there good reason why they should go to a different school? Okay. Sibling placement, same thing. Are siblings placed together, or is there a good reason why they can't be? Or if they're not placed together, have reasonable arrangements been made for visitation? Okay, and you're probably going to have a lot of information and recommendations to make about that. Psychotropic meds, I don't know, maybe. I could think of situations where you might have something to say about that. But hopefully we would be talking about that first.
Would that be medication that the mother or father are taking?
No, the child. If the child is prescribed psychotropic meds, the judge has to know what they're taking it for, how much they're taking it, how often. Yeah, that's the responsibility of the court. When a child's within the court's jurisdiction, that's one of those specific things in the statute that the judge has to keep track of himself, herself.
Yeah, in this person, you should almost always have to leave the child and second topic that she makes a point.
Mm-hmm.
And we should be putting that in our report if we know that they're on it, or if they're old enough to be on, asking if it's on, if they're on,
Right.
and then knowing how much, when, and all those things. I can give an example. We had a child come in one time that was on an astronomical number of psychotropic medications and huge amounts, and we didn't agree with that. So we asked for, we listed what that was, and everybody was like, holy heck. And so based on that, an evaluation was ordered by a different doctor and found that it wasn't necessary. So.
Okay. So that's the adjudicatory hearing. That's what's in the statute. Those are the questions the judge has to answer. Right. All right. Let's look at the last one. Termination. The court may terminate where termination is in the best interest of the child and one of those 5 things. Right? There's all kinds of things there where you may have evidence to give, but you need to know. And this is where, and I don't think I put this anywhere in the slides, but if you're getting ready for a termination trial, you should have a copy of the petition, and you should know which of these grounds the state is alleging. That'll help you narrow it down. Because they can't just put them all in there, because if they put it in the petition, they have to prove it. So if the child's been neglected but not abused, well, then they can't prove it.
And how do you get a copy of that petition?
We have it.
Okay.
We
Yeah.
always will have it.
Okay.
We'll always have it.
That we were looking at.
Okay. All right.
Yep.
I'm just asking because that's probably where I'm headed.
Okay. So that's okay. So termination in the best interest of the child and one or more of the following. Or Section 2, the court may grant an order and may rebuttably presume that termination is in the best interest of the child, where rebuttable presumptions means normally when you walk into court, we talked about that 50% plus 1, the scale just coming down. Normally everybody's supposed to walk in evenly. Okay. Rebuttable presumption means on this question, we already won unless defense counsel can turn that around. Okay. That we don't have to prove best interest of the child where one of these other things is going on. Okay. And these, by and large, are your aggravated circumstances. The child was conceived as a result of rape, incest, lewd contact with a minor, or sexual abuse of a child. abandonment, chronic abuse or neglect, sexual abuse against a child of the parent, torture of a child, any aggravated sex offense, battery or injury to a child that results in serious or great bodily injury, voluntary manslaughter of a child, or the parent has committed murder, aided and abetted a murder, and that's not of a child, that's just a murder. We're okay taking kids away from murderers without much else. If they're convicted of murder, it just makes sense.
Or solicited a murder, which means you paid
Or
somebody else to
solicited
do it.
murder, right. Or you don't even have to pay them. You just say, how much would you charge to go murder my wife?
Yeah.
I just solicited a murder.
Conspired.
That means work together with.
Conspire means two or more people making a plan to commit a crime, and someone, one or the other of them, or one of those two or
Believing
more
that
people, takes some step toward the commission of the offense. Yeah, we can sit here and talk about committing murder all the live long day, but until one of you actually goes out and does something, buys the gun or steals the getaway car or something, we haven't committed a crime until one of us takes a substantial step.
What you're saying
We
is you're
cancel
not
ladies'
willing to
night out a
push
lot.
your
Okay, and again, you're gonna know which one the state's alleging. Okay, so that's 16/2005. It's not in the Child Protective Act. Termination actions have their own chapter. Okay,
Can you talk, are you gonna talk about that?
talk about
Why
what?
they have their own chapter. People often ask why we don't do termination hearing reports. You want to talk about that? Can you talk about that?
Go ahead,
No, go
because
ahead.
I don't know the answer.
Well, because it is a separate action and
Oh.
it's based on evidence, and so the judge can't see anything. So if we were
Oh.
turning in a report, they would be reading evidence, and it's
Right.
a brand new trial.
So there's not
I
a,
didn't know that, but it makes perfect sense now that you say it.
Oh, well, yeah, technically what they're supposed to do is have a different judge than the judge that's been overseeing it the whole time. That can't always happen in our region because there's not very many judges. But if the same judge is over here seeing that termination hearing, they're not supposed to use any of the previous information that they've had. It's a totally different hearing, brand new, all new evidence, and that's why they can't have a.
It has to be an unbiased.
Okay, but
Yeah.
that also means that you can't shortcut things.
Exactly, and we had that happen once.
Your
We had
judgment. Yeah, I'm sorry.
I'm sorry.
All right.
We had
Go ahead.
we had a hearing where it was the same judge who had been throughout the case. So when we went to do the termination, it was like, oh, this is a no-brainer. They've done nothing, but we didn't go over the case plan, didn't address it, and so the judge denied it because basically he simply didn't cover everything that was supposed to be covered in the hearing.
Right.
Everyone assumed that he would know what had already happened, but he couldn't do that. That's actually happened twice.
And that should be up to the state's attorney
Yeah.
to make
To
sure
all
that
attorneys.
they are, yeah,
All attorneys,
to
yeah.
make sure that those are followed through.
Well, but if the state files the petition, the state has the burden of proof.
Right, that's
Mhm.
what I'm saying. The state
Yeah.
should have that list of things they need to go down.
But even our attorney could have still done that, and we would have been covered.
Right.
But nobody did it, just assumed, and so
you know what happens when you assume, right?
yeah, exactly.
Okay, so 16/2009, the court's findings with respect to grounds for termination shall be based upon clear and convincing evidence. I explained to people that preponderance of the evidence is 50% plus. Beyond a reasonable doubt is anything short of UFOs, 100%. Clear and convincing evidence is more like 75%. Okay, it's not preponderance. It's something more than preponderance. He has to believe your case way more than he believes the other side. Okay, there's one cool exception. Remember where we talked about most of your report is made of hearsay and most of your recommendations are based on hearsay? Relevant and material information of any nature, including that contained in reports, Studies or examinations may be admitted and relied upon to the extent of its probative value. Because, and now this makes even more sense to me, because like Z was saying, it's a brand new action. It's not part of the existing case. It's a brand new action. The record has to be complete. But that doesn't mean all the work that you've done by order of the court gets thrown out. Okay? All right. So while you're fairly likely to be called to testify at an adjudicatory hearing, you're almost certainly going to be called to testify at a TPR.
And can I add one little
Yes,
tidbit in there? How you
please.
talked earlier about keeping your notes very thorough, that comes into play. For instance, sometimes we have cases that are 2 or 3 years later.
Yeah.
You're going to want to be able to go back to year 1 and say, on December 12th, I spoke, or, this happened. And that's the only best way that it's going to happen.
You can refer to your notes if you ask permission.
And another
But you
thing,
have
that's
to
why
look
we
at it
ask
and
you
then-
for your notes.
Mhm.
Just so that we have them in case.
Yes, we'll have them on the file. We'll print them out for you when it's time. Absolutely.
Yeah.
So if we don't have them and you don't have them, it didn't happen.
Okay. Pam, I got your text. Were you able to hear what Sunita was saying? Is she?
That's amazing.
Okay. Okay. All right. So then we've talked about, whoops. What are the questions the judge has to find the answers to? What information do I have to provide relevant to answering those questions? Again, start with the statute. Once you know what has to be proved, you can match the information you have to the elements at issue. So this is going to be fact specific, but there's going to be patterns you see over and over and over. And okay, remember that evidence must be relevant. If it doesn't relate to one of the things that you have to prove during the fact finding, it shouldn't be presented. Again, the judge will give you a little bit of leeway on that because he does want a broad understanding of the complete circumstances of the child. But over the life of a case, like Z was saying, a case that can drag on for 2 or 3 or hopefully not 4.5 years, you will have accumulated a lot of information, but not all of it will add anything to the fact finding that you're doing. Okay?
And the fact finding is in statute.
Right,
What the judge needs to say in the statute. Okay.
right. Okay. In many cases, it might help to make a timeline, especially if you've been on the case for a long time. Placements, services, behaviors from the parents, meetings, conversations with mom and dad, if you intend to use that conversation, other things. If there was an arrest in the middle of anything, even, or it helps to make a timeline. And it doesn't just help you remember everything, it helps you think about the case in a linear manner, okay? Instead of, because everybody organizes their case in different ways in their head. The substance abuse concerns over here and the mental health concerns over here, or maybe this child over here and the stuff to deal with more with this child over here. Timeline helps you think about the case chronologically, and that helps you put things in order. Because when you present it to the judge, you want the judge to be able to understand it, and the best way to do that is to present it in a linear manner. Especially if it's a brand new judge who doesn't know anything about the case. And also, you can use that at trial for refreshing your memory if you forget. Put a bookmark there because I'm going to come back to it. All right, so just taking a quick look. Let's say the state is alleging that the child is within the court's jurisdiction because there's another child that was abused. So we're in 1603 sub 2. This child that we're talking about, the child that we're looking at for purposes of this hypothetical, wasn't abused herself. A sibling in the home was abused. So what do we got to prove? The court's taking jurisdiction over the sibling that was abused. We got to prove this child lives or has custodial visitation in the same house. And your recommendations with respect to whether this child has been exposed to or is at risk of being a victim of abuse themselves. Right? And you may well have a lot of information about that by the time we get to adjudication. That's criminal history.
Having had previous children, parental rights terminated should be significant on the current child.
Oh, yeah, absolutely. That would be, if they were involuntarily terminated, that would be an aggravating circumstance.
Is that in all states?
No.
I doubt it. It is in Idaho and Washington, though. Okay. All right, and we actually went through those when I was still on step 1, but we talked about some of the things you may have information about. All right.
So I have, so
Yes.
now this, the questions that we work on answering are only the ones that stayed listed in that original petition, right? Because there's a lot of other things listed
In the
here,
statute.
in the statute, but what
Right.
we use for what our fact finding is what is stated, that's all the judge is gonna look at, is
Yes.
what was stated in the petition at the start.
Yes. Okay. Theoretically, the state could amend the petition partway through the trial.
Okay.
I would hope they wouldn't. But yeah, the judge, I don't know if you have a provision like this over in Idaho. In Washington, there's a provision where the judge can conform pleadings to the evidence produced at trial. You know, maybe your theory of the case isn't 100% right. And maybe it comes out that I'm having trouble coming up with a good example in the child protective world. But let's say it's some other ground than the one that was in the petition. The judge would almost certainly allow the state to amend their petition. So to anticipate where we might be going with this, should you prepare other grounds that are in the statute that aren't in the petition if they might apply? Yes. If they might apply, I think you probably should. And maybe call the prosecutor and say, why aren't you alleging 1D instead of 1B? Or both? Yep. Okay. All right. So, oops. I was going to show where the information that you found in your investigation is most likely to show up. Okay. Okay. All right. Last thing I want to go over. Who's likely to call you as a witness? The state might call you as and I'm going to put friendly in quotes because that term doesn't apply. You're technically an opposing party. Okay.
But if you happen to agree with the thought process
Right.
that they're on, then
they're going to softball you.
Yeah, they're going to be nice.
Yes. That's why I put it in quotes. They don't represent you. They're not on your side. You just happen to both be going in the same direction. Okay. A parent's attorney may call you, and we'll talk a lot about that. Your attorney might call you on your request, but you kind of have to be ready to deliver the information you need the judge to hear, no matter which happens. Okay, state's attorney always presents their evidence first because the state has the burden of proof. They're the people who filed the petition for adjudication or for termination, whichever. It was the state that filed it. So they have to prove the allegations set forth in the complaint. All those evidence. If the court doesn't find each of those evidence, the court can't make all the appropriate findings and conclusions the statute says they have to make. And in a lot of cases, the petition could be dismissed. Z talked about that, where the state didn't provide evidence for the court to find all of those. And sometimes the statute says if the court doesn't find an adjudication, if the court doesn't find the child comes within the jurisdiction of the court, the petition has to be dismissed. Okay? So that's part of the state's burden. So before the state rests their case in chief, they have to make sure. And that's why you'll hear goofy things at trial. And this happened, oops, I'm so sorry.
Are you awake now?
Yeah, no, I'm paying. Yeah.
You'll hear goofy things at trial. And this happened in Nez Perce County? Yes. In the state of Idaho? Where do you think Lewiston is? But there's a reason they ask those questions. That's one of the elements they have to prove. They have to prove this happened in this state and that this is the appropriate venue to have it. So you'll hear goofy questions like that sometimes. It's because if the state doesn't ask that question, their case gets thrown out.
We had a case that the whole case adjudicatory was based on where the parents lived at the time.
Yeah.
Because they were living in two different places. So, you know, it was a difficult one.
Mm-hmm.
And it's where the parents
They
live.
left to go have the baby, is what we think.
Mm.
But they were homeless semi, but not really. It was sticky. It was really sticky.
Ultimately, no. The question is going to be, is the child living or can be found within this state?
But what about county? Because, is the state, it's a state jurisdiction, not
It
county.
is, but
It's
these
this,
folks
but
wanted to.
county goes to venue rather than jurisdiction. But yes.
Okay.
These folks lived down in the Boise area and they wanted their case moved down there because the department down there said they wouldn't remove them.
So it was a matter of
our fight
convenience.
was to keep them here. Yeah. So
Sometimes it would be convenient the other way if they move, because we've had that where one of our cases moved to get away from the bad influences.
Mm-hmm.
They moved to a different place, so we had to travel way far away to go to work.
that was not the case. Yeah.
Right. So if the state calls you during its case in chief, it's going to be to testify to facts that only you know, or maybe that you know better, such as admissions made to you by a parent. Remember, if we're doing our jobs correctly and developing rapport with everybody, parents are likely to say stuff that they really shouldn't say to you.
Or they say it because they're
They say it because
Maybe.
they're mad, and then you write it down before you leave the parking lot.
There you go.
It's case in chief.
Case in chief. Okay, yeah, I should define that, shouldn't I? When I say the state has the burden of proof and they go first, okay, the state gets to present all their direct evidence and they have to check off all the boxes on the petition and then they rest. And during that time, there's cross-examination and redirect and all sorts of stuff. But when the state rests, that means that's the end of their case in chief.
Their turn.
And, right. And then it's defense counsel's turn to present their direct evidence. And the state will get another chance because they have the burden. They'll get another chance at the end to present any rebuttal evidence. But that's not the case in chief. The case in chief is the evidence that they have to put on when they go first to establish all the elements in the petition.
The main bulk of their
Yes.
case. Yeah.
Yes. Okay. State, remember, you have that special out that's in 162009. They can get in evidence at termination through you about stuff that's in your report that wouldn't be admissible if it were offered by another witness. So that's why I say you're almost certainly going to get called the TPR. To bolster the state's recommendations by your own similar ones. They're going to ask you what kind of things you recommended. Okay. If you're called during the case in chief, as a rule, the questioning will not be adversarial. They'll probably ask you both open and closed questions. Do you guys know the difference? Good. Okay. So they'll ask you some yes, no's, but they'll also give you chance to explain. If there's an objection as to your basis of knowledge, remember that lack of foundation, the state's attorney will usually back up and ask you the questions to lay the cobblestones so that your evidence will come in. They'll be good guys. Unless when you disagree with some aspect of the department's recommendations, the state's questioning may get a little more confrontational. Placement, sibling placement, services. If you disagree with the state on the big question, is the child dependent? Should the parents' rights be terminated? They probably won't call you during the case in chief.
Because that's taking away their
Yes.
75% in the eyes of
Right.
the judge.
Yes.
So will somebody call us then?
We
Like,
will
can
ask
our
our
attorney
Oh,
to call
yes.
us? Okay, got it.
Okay. Yes, yes, yes. Okay. Even though if you're disagreeing on some of those, not the big questions, placement, stuff like that, services, the state may still ask you about that for all kinds of reasons. First off, attorneys are always trained, if there's bad information, they want to get that in front of the judge first, because then they can control the first hearing. The first time you hear something makes all the difference, because then when you hear it later, you're like, I already knew that. Okay? They can put it in on their terms, making it seem like it's no big deal. Or they might ask you about it so that they can ask you follow-up questions to make it look like you're wrong. Okay?
In essence, still controlling
Right.
how
Still
much
controlling
that
how
is.
the bad information comes in. Being able to go first means a lot at trial. The best thing you have going for you over the department, and I'm talking about over the department because the state represents the department, your recommendations are always going to be based on observable facts, your knowledge of the people, and the history of the case, rather than a policy manual. Okay? Really? I put that slide in there twice? Wow. Okay.
We looked at it closer the first time.
Okay. So if you're called to the stand by the state's attorney, once they're done asking you questions, then the parents' attorneys will get an opportunity to cross-examine you. I got a whole section on cross-examination. We'll get there soon. This is, I'm sorry?
Five parents.
Oh, yes.
Yeah, but they think it's possible. But they don't. They're not even, you know,
They won't. If the parents
If
are
they
here,
haven't
the
done, if
attorney
they haven't
will
done
speak.
anything in a year, they're not going to come up into the court and go, oh yeah, I want to do 10 minutes worth.
Don't go into court. Don't
but
go into
that's-
court with that
No, I'm not
assumption.
saying that.
Right.
It wouldn't be that I wouldn't be prepared, but
Right.
that's usually how it happens.
Yeah, but not always.
No.
You're absolutely right. But not
You would
always.
have those answers, you would have that information, but
But what about when you have that new attorney who's trying to make a name for themselves?
Right.
Yeah.
And that has happened, where they've never even seen their client, their client's never shown up.
Right.
But it's also a duty to, what's the word called?
Represent.
Yes.
Zealously advocate on behalf of the client.
Right.
Yeah, and that's actually coming up. They'll confine you mostly to closed questions, and they're not going to give you much of an opportunity to explain. They want the information to come in their way. And so I'll always remember, and this will come up throughout the rest of this, if something that seems bad at the moment comes out while you're being cross-examined, don't worry. It's not over. Your attorney will get a chance to question you. The state's attorney can question you again on redirect. They can what's called rehabilitate. You may have to remind them.
Yeah.
But they can really rehabilitate even testimony that you think is damaging. Okay. So once the state's rested and their case in chief is over, then the judge generally is going to allow one of the parents' attorneys to begin presenting next. Theoretically, every judge is different, and I don't know how Judge Olds does it. I don't know how the judge in Clearwater County does it. Theoretically, the judge might let you go next after the state, but probably not.
They go to the
Parents.
and then over to us.
Right.
Prosecution, parents, and then we're left.
Yeah. And that's the way almost every case I've ever seen has gone.
He's right here.
Okay, so if you weren't called as a witness during the state's case, you might be called by mom or dad's attorney. So you need to be ready for that eventuality. And this is different from cross-examination. Okay, cross-examination is when the state puts you up or your attorney puts you up and you talk about stuff and then mom or dad's attorney comes after you about what you just talked about. Okay, this is different. If mom or dad's attorney calls you as a witness, they get to ask you about anything. Well, anything relevant. Okay, that's why you need to anticipate who might call you as a witness. Yes, I'm sorry. Are you having trouble hearing? Okay. It's possible that a parent's attorney could call you to the stand again, even if you testified during the state's case. One reason they might do that, especially if you were the last witness before the state rested, mom's attorney might jump up and say, call the guardian ad litem to the stand, please, before you even have a chance to get a drink of water. Throw you off your rhythm. They might. Okay. But more likely, because I like to think that most attorneys aren't jerks, more likely, okay, the reason I kind of touched on this a minute ago, cross-examination. The state calls you up, they ask you all these questions, and then defense counsel gets to cross-examine you, but they can only ask you about this. Technically, under the rules of evidence. And one of the objections that you might hear when you're being cross-examined is your attorney or the prosecutor may stand up and say objection beyond the scope of cross. Scope of cross-examination means they're only supposed to be cross-examining you about what you just said. Now, because it's a bench trial, frequently the judge will allow them to venture beyond that into other areas so that what I just described doesn't happen. You get off the witness stand and then get called right back up. That's tough. Okay, so frequently the judge will just allow them to go beyond the scope of cross-examination, but it's possible that the opposing counsel didn't even try. That it didn't even occur to them that the judge might give them some leeway, so they recall you again. Okay. All right. Whew. Okay. If you're called during the parent's case, they are almost certainly going to try and limit what you say. They're going to stick mostly to closed questions. They'll ask you a yes or no question, and when you start to explain your yes or no, they're going to ask you another question right away so that you don't get a chance to explain. Their questions may get argumentative. They may purposely try to confuse you. Again, though, stay calm, breathe. It's not personal, and all the other attorneys that are more friendly to you are gonna have a chance. They're gonna have a chance to question you and allow you to give your evidence more freely.
When they try and stack one question on the other,
Mm-hmm.
if you just look at the judge and say, Judge, you didn't let me answer the first question.
Well, they did though. Well, if the attorney's not letting you answer the question they asked, one of the other attorneys
Yeah.
better be jumping up and shit, that's called badgering the witness.
Yes. Or at least involved.
Yeah. But no, the example I was giving was they'll ask you a yes or no question, and you come back with no but, and then they ask you another question so you don't get the but part out. Okay, so you answered the question. You just didn't answer it the way you wanted to. You answered it the way he wants you to, or she. All right. And we've kind of talked about why it matters who calls you. You have to be ready for what sort of questions you're going to be asked and how they're asked. You got to have some strategies for handling the tough questions. And you have to have a plan to getting the information the opposing counsel wants to keep you from saying. Okay. So, handling cross. Know where the weak points are in your case. Because there are going to be some. There are going to be some. And without even getting, excuse me, I could stand here for 5 minutes and try to think of hypotheticals. But you guys know, there are going to be weak points. Know where they are. Defense counsel should never be able to point to any weakness in your testimony that you haven't already thought of. So think about and then practice how you might answer some of those questions. Because even you want to deliver your opinion confidently, but you still want it clear to the judge. Yeah, I thought about that. But this is my recommendation anyway. Okay? And be prepared to explain why that particular weakness doesn't undermine anything else you're saying. If that makes sense. I know we're talking about these kind of vaguely without hypotheticals, but I'm also taking much longer than I was going to. Story of my life. Okay. Know why you're being cross-examined. Why are they asking you that? There's all kinds of reasons. They're trying to make you help prove the parent's defense. They're trying to show some flaw in your work. They're trying to show some flaw in your understanding of the facts. Or they're trying to make you admit to some bias or other improper motive underlying your opinions. Okay? And they're not going to come out and say, you just don't like my client because she's poor. I'm not going to say that. They're going to ask you 6 questions and make you accidentally imply it if they can. Don't take any of it personally. And this is what we were talking about before. Defense counsel has an ethical obligation to represent their client, whether they agree or not, whether they think their client should ever get their children again. They don't get to make those judgments. They have a job to do. Any attorney who throws the case is not going to be an attorney for long. Okay, and that means that a competent, and we're assuming that defense attorneys are competent, any competent defense attorney is probably going to try and poke some holes in your case. Expect it, but don't take it personally. They're attacking your work, not you. If you take this personally, you're externalizing something that internalizing something that isn't internal. Okay? They can only attack your work. They can attack you. You may still encounter bad behavior from defense counsel, but that still isn't personal either. Some attorneys don't know how to defend a case unless they can be an asshole.
Yeah, they will name call and all kinds.
Right. I've dealt with some, oh my Lord, I could tell you some horror stories about just awful, awful attorneys. But that isn't personal. Again, I mean, they're rude, but it isn't personal. They're like that. If they're like that to you, they're probably like that to everybody. Okay? You can improve your appearance of impartiality. You can improve your, what's the word I'm looking for, credibility. When you deal with the asshole attorney exactly the same as you handle the questions that came from your lawyer. If you can stay calm and breathe and remember, they're not attacking me. This isn't personal. If you can stay calm through that and be just as nice to the asshole defense attorney as you were to the prosecutor,
One
yes,
with kindness, yep.
your credibility level just went way up in the eyes of the only person whose opinion matters. Okay, I've always told clients right before trial, if I catch you sounding snippy with the opposing counsel in a way that you don't when I'm asking you questions, I'm gonna fire you. I can't really fire, I'm gonna threaten to. I never ever want a client to answer my question nicely and be rude to the other party. That's a good way to seem like you've got something to hide at the very least, or like you don't know what you're doing. Okay. And this actually goes with any time you're being asked questions, but listen carefully to the question and only answer what is being asked. If it's a yes/no question, give a yes/no answer. Defense counsel is probably only going to let you give a yes/no question or a yes/no answer. Don't volunteer information outside of a direct response to the question. Again, you're going to get another chance to testify, or you're going to get another chance to be questioned by a more friendly lawyer. Don't volunteer information that's outside of cross-examination questions. If there's an explanation to that question, you can get it in later. Oh, for crying out loud, that was the next bullet point. If there's something you need to explain further, you'll have a chance, either during follow-up or on redirect or questioning by one of the other lawyers. Okay, as much as you can, answer cross-examination questions by repeating the exact words you gave on direct. Stick to your talking points. Okay, because defense counsel will always want you to admit to something you might not want to say. And if you don't ever hardly say anything different than what you said on direct, it ain't gonna work. If you begin every response with, as I said earlier, counsel, you win. Okay, don't let them throw you. As much as you can, stick to the same words that you gave when you were asked those questions on direct. Okay, don't be afraid of the hard questions. You're gonna get them. Here's a big one. Madam Guardian, won't little Johnny be harmed by having his parental relationship with mom permanently severed? What's the answer? Yes. Yes. He absolutely will. Of course, unfortunately in this case, that's outweighed by the harm caused by remaining in limbo with a parent who may never be able to provide Johnny with a safe home. But the answer is yes. Don't be afraid of that.
So we had a case where there was 3 little boys.
Yeah.
And they had been with the foster parents for so long that they had bonded with the foster parents, and the foster parents, I mean, it was just like a family. They bonded with the foster parents.
Yeah.
And one of them had been with them since birth. And so then here are the parents that have done nothing, and in and out of jail and drugs and all of that. So we're at the TPR, and that question was asked to me.
Mm-hmm.
Is it going to hurt little Johnny to sever the rights? And my answer was yes. And they let me do the but it's going to be bad to be either way, because these kids know these foster parents as their own parents.
Right.
You know, so either one of them would have harmed. But this is the foster parents were the least of the two. But they did let me finish that statement.
Good.
Yeah, which was good.
You may have had a defense counsel who agreed with you.
Yeah, that happens sometimes.
All right. When you face that hard question with the right answer, yes, even though on the surface it seems like it might be a little damaging to your case, it demonstrates that you're carefully considering the testimony you're giving. It's a bad conclusion, but it's what's in Johnny's best interests. But the answer to the question is yeah. Yeah. All right. Don't brainstorm. Okay? The witness stand is never, ever going to be the place to be thinking about what you or the department or anybody else could have done differently. If defense counsel's questions get you into that mindset, they're trying to get you to blow your own case. They're either trying to shift, like parents not getting it together, they're trying to shift the blame onto you or the caseworker by making you say, well, I sure wish the caseworker would have. Okay. Also, there's part of that legal standard about reasonable efforts. They're trying to get you to blow a hole in your case by showing them, well, maybe there were some reasonable efforts that got missed. You just lost. Don't brainstorm. Okay. Here's your answer. I understand the question, but I'm here to report on what happened, not to speculate about what could have happened.
And then the lawyer turns into his himself.
Right? All right. Remember, you'll always get another chance. Whoops, hey, I didn't know I could do that. Remember, you'll always get another chance to rehabilitate an unhelpful answer. You might need to remind your attorney to go down that line of questioning to make sure the fuller answer comes out. As a last resort, okay, don't talk to the judge, okay? When you're being asked a question, address your answer to the person who asked you the question. You can look at the judge while you're speaking, okay? You can look at the judge, but you're not talking to the judge. You're talking to the person who asked you the question. You can look at the judge, but you're not talking to the judge. As a very last resort, if you've got defense counsel who is just dropping stakes from orbit all around you, you try to go this way, you know, and he's, as a very last resort, if you have to, you could say, Judge, may I explain? If that's the thing that keeps you from blowing up on the witness stand, as the last resort.
Or crying.
Yeah. Okay, but use that sparingly because you're not there to talk to the judge. You're there to answer questions.
We can't call badgering the witness either, because that has to be our attorney.
I would hope.
You
Okay, remember folks, I'm new and I know about half the defense counsel, but I don't know who's going to be representing you and I don't know how seriously they're going to take it when they have to turn around and represent a parent in the next one. I don't know. I don't know that yet. So yes, I would like to think that your attorney will stand up and say, for crying out loud, Judge, can my client or can the guardian ad litem get a word in edgewise over here? I would hope they do that.
I think you do have to, because I've experienced like feeling like you didn't have enough time to prepare the attorney I would do. I think we need to push for that.
Yes, yes. And if you need me to help you push for that, I absolutely will.
Because I can remember feeling like, wait a minute, she asked me about that. Yeah. Yeah. Can you also attorney instead of like the prosecuting?
I would hope that if it came down to the examining attorney's behavior toward you, that it would be your attorney that was.
Yeah.
That you pound in and say, you know.
Yeah, I'm talking about your lawyer. State could theoretically too. Okay, 5 more slides. Here's the general rules for everything. Cross-examination, direct examination. Professionalism in appearance and behavior is critical. Remember we talked about credibility, the C word that I get to say. This applies when you're on the witness stand and when you're off it. When you're sitting at counsel table, listening to other witnesses. Just on the conservative side, when you go to court, studies show that judges, despite all their talk about being able to separate good evidence from bad evidence and being neutral and unbiased, men wear black, women wear black, men wear blue, and the judge is more likely to find you credible. Okay? Just on the conservative side for court.
However,
Yeah.
jeans,
Yeah?
we're against jeans in court, correct?
I hope so.
Why would you wear jeans to court?
I'm just,
Yeah.
it's just, it's
Come on.
Yeah, you remember who you work for. You work for the judge. I wouldn't show up for a meeting with my employer wearing jeans when everybody else is in a shirt and tie.
Right.
No, no. So, appear and behave professionally. You are hired by the court for the purpose of that case. All right. Know what you're going to do with your hands. Okay. If you're sitting, you can do that unless you find it uncomfortable and distracting. Okay. No.
Except with my hands,
Right.
as you very well know, and everybody.
So, know what
You're
you're
allowed
going
to
to
do
know what you're going to do with your hands. I frequently will tell clients just put the knuckles together right here. Put the knuckles of this hand in this hand. This is actually called a mudra. It's a meditation thing, and let this rest in your lap. You'll be surprised. You'll be surprised how many clients can do that for an hour without even realizing they're doing it.
Mm-hmm.
Okay. And I'm not saying you have to do that. I'm saying you need to know before you come into the courtroom what you're going to do with your hands. Here's the other thing. I used to know an attorney who was always doing this while he was asking questions, because if he put his hands in his pockets like Atticus Finch, and his keys are making more noise than he is, right? Because he's trying to seem like this down-home country lawyer and messing up the record. Know what you're going to do with your hands. This is a personal thing with me. Don't take your file up there with you. By the time you get to a termination, especially, there's nothing worse than a witness who wants to flip through their file and take 10 minutes to find something before they answer the doggone question. Everybody else is thinking, Judge, can we just take lunch? Don't take your file. Please. Don't take your file up on the stand with you.
Should we take our notes, like your timeline? Like the timeline
would.
and that? Okay, so we can, and it's okay to take that up with us.
Yes. But here's the thing, though. You got to get permission to use it.
Oh, so it's there, but you have
Is
to
that
ask
ahead of
if I
time?
can look at
Right.
that.
And you can plan this ahead of time with the prosecutor or your attorney. Say, I don't remember. May I look at my notes to refresh my recollection? Or if you've worked it out with your attorney, say, I don't remember, and your attorney knows that this is the cue to, do you have notes in your hand that would help you refresh your recollection? Because then you can use them. You're only allowed to use those to refresh your recollection of something you don't remember. But you can't get up on the stand and read
You
from it.
can't read from it, though. You
Oh.
can look at it and read it, and then put it down and say,
Right.
Answer the question.
answer the question. You can't read from it, otherwise you have to disperse your notes
To
all
every
the
attorney.
attorneys.
Yeah.
Yeah.
But you can use it to refresh your recollection if you get permission first. Okay. And this is part of professionalism too. Don't allow yourself to get frustrated or combative no matter what anybody else in the courtroom says or does. Maybe it's not even defense counsel. Maybe it's dad. Maybe dad is making crude gestures while you're testifying.
Shaking his
Okay.
head and doing that kind of stuff.
If you have to use the judge, say, Your Honor, I'm having difficulty concentrating with father making those gestures. Odds are the judge has probably seen it too. But don't let yourself get frustrated or combative. If you need a break, ask for a break. Just if the attorney is really coming at you and you can feel, your heart's pounding and your face is turning red, just ask if you can take a break. The judge will know what's going on. If the attorney is coming after you, remember you work for the judge. Okay? And if you're not adequately being defended by somebody else standing up and objecting, you need a break, the judge will need to. Okay? You're not there to be attacked. Okay. Present your affirmative position confidently, straightforwardly. By affirmative position, I mean, this isn't an academic exercise. Okay? We're not talking in hypotheticals. If you feel that you've done the work and you're satisfied with your recommendations, and you better be, otherwise why are you signing it and putting it in front of a judge? Then you're doing yourself a disservice by appearing otherwise. Okay. You're the expert on the facts. You're the one who's done the investigation. Don't ever say this in court, but you probably know more about this case than almost anybody else involved in it, including the caseworker in many cases. Sometimes including the parents.
Can I,
Yeah.
what I like to always say to people is if you think if it's in the best interest of the child, then you're right.
Yeah.
Mhm.
Yeah.
So stand by it.
Yes. And don't be afraid to say that.
If you have what? If you think it's in the best interest of the child or it's in the best interest of the child, you're always right.
Yeah. If you think it's in the best interest of the child, you're always right. And that means you shouldn't be afraid to say that loud and clear.
And I have
to
to,
right from the parents too.
Yeah.
So that's even when the parents are making a big deal and a big emotional scene.
Yes.
I have to say, I mean, I say that a lot out loud. This is in the best interest of the child because it kind of grounds me and it brings me back to my base. Because they're arguing with me and they're, saying, well, why this, why that? And just go back. It's the best interest of the child. I am about the best interest of the child. And then it makes it easier to just then not argue, but say what I need to say. Yeah.
So we covered mudras, now we've covered mantras. We're like halfway through my meditation class already. Thank you. That was really good. Thank you. Okay. Give your answers out loud because nods and gestures, you can nod or gesture while you say the words, but you have to say the words because if it's not on the record, it didn't happen. And if a parent loses, they're very likely to appeal and there has to be a record. Okay. Speak clearly in the right position to be captured by the recording system. Every courtroom is going to be different. Some of them are going to have little discs that work as mics. Some of them are going to have little goosenecks in your face. If you can, watch the witness that goes before you to see where they sit. If it's a law enforcement officer, they're pros. They're on that witness stand all the time. They'll show you exactly where to put your face.
We can't be in the courtroom until we testify.
Yes, we can.
Oh,
You're
and
party
Judith-
to the
At a
case.
shelter care hearing, yeah, you're a party to the case.
Well, at the termination hearing, because at the adjudicatory hearing, I had to stay outside, I thought Ashley said.
You shouldn't have had to.
No.
You're a party to the case.
You're a
You
party
should
to
be
the
there.
We can
case.
be there the whole time.
Even in the
And hear
termination.
the other, because I thought that was about not having other testimony influence what you say.
If counsel, and I don't know your local practice, but in most jurisdictions, if one of the attorneys asks for witnesses to be what's called sequestered, then a witness who hasn't testified yet can't hear the testimony that goes
Right.
before. Remember, you're not just a witness. You're a party. You have an absolute right to be present in any proceeding.
Anything
And
that
if
you're gonna
anybody tells you
testify.
different, please tell me so that I can give them help.
Yeah, because that thing, when we were gonna have the adjudicatory hearing, I was gonna stay upstairs and Ashley was gonna come and get me. She was gonna send somebody to come and get me when it was getting close to time for me to testify. So yeah. I'll have
That was wrong.
Yeah, all right. Okay.
Don't say I believe or I think when what you mean to say is I know. We do that. Colloquially, I believe he's about 3. No, how old is your child? 3. Okay. So,
Or can I say, if you don't know, then say you don't know.
oh, yeah, we'll get there. We'll get there.
Okay, sorry.
You're all right. Remember who you're talking to. You're talking to the attorney who's asking you questions. Don't look at your attorney when you're answering a question. Like I said, you address your answers to the attorney who asked you the question. You can look at the judge, and if you watch police testify, they're taught to do that all the time. A lot of caseworkers, if they're experienced, will do that too. They'll get the question, they'll deliver the answer this way, even though it's aimed at him. You're looking at the judge. Police do this all the time. They're taught to do this. And you can do that. Don't overdo it, because you're not a professional witness. You're a professional. Okay? But don't look at your attorney when you're answering questions, because that makes it look like you're looking for help. Okay? Be certain you understand the question you're asked and stick to that. If you didn't catch it or you aren't quite sure, ask the attorney to repeat. I'm sorry, could you repeat the question? If you need a moment to think, because remember, your heart's probably going to be going faster than normal. You're going to hear it. If you just need a moment to think, I'm sorry, could you repeat the question? Even if you understood exactly what he said, but you just need a moment to think. I'm sorry, could you repeat the question? If you don't understand the question, ask him to repeat it or just tell him, I'm sorry, I don't understand your question. Because attorneys will sometimes ask you confusing questions, hoping that you wind up in the weeds. Or you get people like me who sometimes ramble a little bit, and by the time I'm done with my question, you're going, what was you asking me?
Yeah.
Right? So it might not even be bad behavior. It might even be your own lawyer. You just might not understand the question because he's wandering around before he gets to the point. Right? Okay, so if you don't understand the question, don't be afraid to say, I'm sorry, I don't understand the question. Stick to the facts and to the truth. If you don't know, say that. Don't be afraid of the hard questions. I don't know. If you don't remember, say, I don't remember. Don't say, I don't remember, I think it was. Don't do that.
Yeah.
You're guessing. We don't guess. We make solid recommendations based on facts and observable evidence. Okay. Avoid the temptation to embellish, even a little bit. Okay. And by embellish, I'm not saying lie. I know none of you guys would ever go into court and lie. But coloring the way you tell the story even. We don't need to do that. Remember what Z said. If it's in the best interest of the child, if it's what you're recommending, you're right. You don't need to. Okay? And also, if you get caught, there goes your credibility. Okay? We don't need to. Stick to the facts clearly, and you don't need to embellish them. And after you get done testifying, always, always, always get some feedback. If one of us is there in court with you, we'll happily talk with you. Talk with your attorney, though, for sure. Ask them, what did you hear my testimony to be? What do you think the judge heard my testimony to be? Do you think the judge heard what we were trying to say? Was there a way I could have delivered that better? What do you think that I should work on for next time I have to do this? They'll happily tell you. Okay? Attorneys know who are good witnesses and who aren't. And they'll be able to tell you why. Okay? It can sometimes be hard to hear, but it's necessary. Nobody is born knowing how to give testimony. It's not a natural thing. It's a professional skill, and you only develop it through practice. So getting feedback is critical to getting better. And breathe. Do you guys have any questions? I know that was a lot. I actually went a little later than I thought I would.
It was good. Very helpful.
Thank you.
I think I would like to, in the future, hear more about aggravated circumstances because I feel like I've had 4 cases. Half of them have had aggravated circumstances. So, for future things.
Sure. Sure. It's hard.
Yeah.
Okay. So if anything comes up, like you realize on the drive home, oh shit, I should ask Rick about. Throw it out. Okay, I am here for you guys. And you asked me the question that you came up with. Maybe 6 other people didn't ask, but they had the same question. Okay. So anyway, thank you so much for the gift of your time and attention.
Thank you.
Thanks for the, whoever supplied them.
That would be Z.
Those cupcakes just have all my name.
They're good.
No, that was so good.
Because they stay here and you don't put them here.
Right?
I mean, we do want them here, but we're ready.
Yes.
We do, but we don't.
I'll get with you when I get back to that.
Well,
You really haven't missed it.
like I
I think
said,
it's usually in a
what
pony one
we would do on Monday, I'll be doing again on Saturday. So you won't really be missing anything.
Yeah, we'll take this. Okay. Okay. I'll see you anytime.
So I will give you my dates for September.
Yeah.
We're going to Arizona for about a week and then we're going to
Thank you.
Wow.
Yeah. And it's all within, I think we leave on the 27th and go to Arizona for that week and then go back for a day and then
Well, I'm sure I'll see you before. I'm sure I'll talk to you
Oh
before.
yeah, well, I'll be in tomorrow. I gotta finish up this report. I gotta finish up this report this morning. Trial conference, we'll just say, oh, yeah, you're right.
Oh, wouldn't that be nice?
Wouldn't that be nice? She seemed amenable to that. but you never know.
You know, good.
It happens often, but they usually wait until it's down to the wire.
Right.
The first termination trial I ever did,
That's where my first one is probably headed to that real quick.
the first termination trial I ever did, Dad had already relinquished. Mom left. She got mad and left half hour into the proceedings. But I still had to keep going on presenting evidence for the day and a half. If she had not shown up at 9 a.m., I could have got a default. She showed up and then got pissed and left. And so I had to present evidence for a day and a half after she left.
I don't know. I'm hoping to just say, okay, fine. After the hearing yesterday, I didn't get a sense of where Dad went because Dad went to go talk to his dad. But Mom was just pissed. Well, we're at, which is every other word she says anyways, but you just kind of go, you know that